Luz, you're on mute. Okay.
Yeah, you should all be on mute.
Jeff.
Craig, please mute yourself right now. Everybody should be on mute right now. Thank you. Good afternoon and welcome to Grand Rounds. I'm Kelly Forrest, an attorney in the Central Florida Collaborative Group and one of the co-chairs of the Grand Rounds Subcommittee of the FACP Outreach and Practice Group Committees. We are pleased to present session 2 of Grand Rounds, a monthly lunchtime training showcasing a different Florida collaborative practice group each month. The first portion of the session will be a group presentation and the balance will be a discussion period where we'll troubleshoot and brainstorm solutions to the unique problem presented in that session. If you have questions during the presentation, please place them in the chat and we will kick off the discussion period with those questions. Once the Q&A session begins, please raise your hand by clicking at the bottom of your screen in the reactions box when you would like to speak. For our first few sessions of Grand Rounds, the presenters have selected the topic. We would like to ask each of you present to submit an issue you've had to address in the collaborative process, whether substantive or process-based, with a short fact pattern for us to use as the foundation for future sessions. You can email them to me or to my colleague and friend, Liz Reboredo, and we'll place our email addresses in the chat. Before we get started with this session, I would just like to announce that our April session will be held on April 15th, and it features the Broward County Group Collaborative Family Law Professionals of South Florida. The topic next month will be the interplay between client control and the professionals' roles in the collaborative process, and will feature mental health professional Randy Heller, attorney Bob Merlin, and financial neutral Ari Harper. Thank you all for coming, and I'm happy now to introduce Sheila Furr, who will introduce her practice group. Sheila?
Welcome, everybody. I'm president of the South Palm Beach County Collaborative Law Group, and I wanted to welcome everybody from all over the state to this Grand Rounds. I've put our email address, choosecollaborative.com, in the chat. So if anybody would like to reach out to our speakers, this will be an efficient way to reach them. I also, in my wearing the hat of co-chair of credentialing for FACP, want to remind everybody that these Grand Rounds will count towards credits for credentialing and re-credentialing. You will be getting a certificate of attendance. Please keep that certificate. Start a folder for credentialing or re-credentialing, and you'll easily get the credits you need for the continuing education requirements. So I now turn this over.
Hi, happy Friday, everyone. I'm Liz Reboredo, and as you heard Kelly say, I am the co-chair of the Grand Rounds Committee for the FACP. And so we're here today. I'm going to introduce the speakers for today, but because our speakers are very accomplished and have a long list of accomplishments, I put a link to the materials in the chat box so you can access not only the materials and the fact pattern for today, but also their complete bios. So for now, I'm just going to keep it brief, and I'll start with Eileen Brody, is a partner of J.D. Gilbert and Company, a certified public accounting firm located in Deerfield Beach, Florida. Eileen is an expert in forensic accounting and is trained and enjoys practicing using the collaborative law process. Eileen has been a member of the South Palm Beach County Choose Collaborative Group since its inception, is currently serving on the extended board of Choose Collaborative, and is also the chair of the Pro Bono Lo Bono Committee. Next, we have Craig Fabricant. Craig is a licensed psychologist in Florida, as well as in New Jersey and New York. He received his doctorate in clinical psychology from the Florida Institute of Technology and has been in private practice for over 35 years. Dr. Fabricant is currently the secretary for the Florida Academy of Collaborative Professionals. And in addition, he's on the board of the Florida Psychological Association and also its ethics committee chairperson. Luz Nieto is also going to be presenting today, and she was born and raised in South Florida, where she received her bachelor's degree in criminal justice from the Florida Atlantic University and her law degree from Nova Southeastern University. Luz opened up her own practice in 2017 and is based out of Boca Raton, Florida. She is a member of FACP and also is a member of the South Palm Beach County Choose Collaborative Group. Ms. Nieto is a committee member of the Family Law section of the Florida Bar and is a member of the South Palm Beach Bar Association, Broward County Bar Association, and Florida Association of Women Lawyers. And last but certainly not least, we have Jeffrey Wasserman. Jeffrey is an attorney and accredited collaborative professional under FACP and has been practicing for over 45 years. Jeff is currently of counsel at Shapiro, Blasey, Wasserman, and Herman. Jeff is currently serving on the board of directors and is a co-chair of the fundraising committee of FACP. In addition, he serves on the board of the local South Palm Beach County Collaborative Law Group, and is also a member of CFLI, CFLPSF, which is the Broward Group, and a member of IACP. Too many initials, too many words. So without further delay, I happily introduce the South Palm Beach County Collaborative Group, who will be presenting on ethics today.
Okay, I'm going to go first, I guess. And one of the first things I'm going to do is try to put a definition to ethics, and then talk a little bit in general about what ethics are and what we need to do. I'm going to come from an MHP perspective. Okay, even though a whole bunch of you are financial people and attorneys, the rules still apply pretty much, are going to be the same. And I'm going to give you first HIPAA's sort of version of ethical standards. It's a duty to care. You have an obligation to avoid acts or omissions which could be reasonably foreseen to injure or harm an individual. And you must anticipate risks and prevent them from occurring. Why do I give that kind of a definition? Because you're going to find that each one of our licensing boards has a standard and a code of conduct, ethical standards in which we function. And if you start violating those ethics, you can sort of get into a lot of problems. Okay, and it's very easy to have complaints made to the licensing boards. I know for 490 and 491 individuals, and some individuals who are very, very well aware of the licensing board, et cetera, family law has the highest rate of complaints against psychologists and mental health practitioners, such as LMFTs, MHCs, social workers, et cetera. And most of them, believe it or not, are in the area of confidentiality and violation of confidentiality. So we have to be very, very aware of what's going on ethically. I will also want to make you aware of two groups of ethical standards. The IACP's Standards and Ethics, which was completed about 5-6 years ago. And there's some webinars available. I know I was part of the panel that presented it, which I'm going to refer to in a few minutes. That'll discuss ethics and standards. There also, which Jeff Wasserman was very much a part of, thank you, Jeff, the Florida Academy of Collaborative Professionals collaborative process for ethical standards. And hopefully those will be available to everybody on the website, the FACP website, very, very shortly. But the first thing I want to do, there are a couple of rules that I think are very, very important. It's Rule 1.1a in the FACP Collaborative Ethical Standards. Collaborative professionals must comply with all professional and ethical conduct requirements applicable to their respective fields. In other words, you got to follow your licensing laws and the ethical standards that are involved in your licensing law when you're doing anything in the collaborative process. That comes first. Okay. Rule 1.1b, collaborative professionals must be in good standing under the licensure or certification required by their respective professions. So you've got to meet the basic standards in your licensing laws, as well as all licensing laws use ethical standards to determine whether you're following the law and following the rules.
Greg, I just want to jump in on that. All of the professionals have their own set of ethical standards separate and apart from either IACP or FACP. The lawyers have the rules regulating the Florida bar. Eileen, you could comment on the financial professionals' ethical standards that are outside of FACP and IACP. It is very, very important that we all understand that we have our professional ethical standards separate and apart, but in combination with what we have for IACP and FACP.
Well, they make, Jeff, they make up the, or all of it, they make up the basis of our licensing laws, which is very important to realize. And it's also very easy for individuals to make a complaint against your license for violation of some of the ethical situations and tie your license up for a couple of years of investigation. What I want to do is start looking at the fact pattern that we have. But before we do and answer some questions in there, but I want to go over something that I think is very, very important in the collaborative process. And that's the collaborative agreement and when that takes place and what happens prior, especially for the mental health professional, okay, which I think is very, very important, which I know a lot of my colleagues know about, but many do not realize. A lot of us will interview the clients prior to the agreement, most of us will, prior to the agreement actually being signed, okay? When you are meeting with the clients prior to that assigned agreement, remember that assigned agreement starts the collaborative process. Collaborative process is not happening before that, and actually the clients can opt out not to do it at that point. You are actually, according to the law, obtaining private healthcare information, PHI. Okay, they could be telling you all their deep, dark secrets, a lot about their situation, whether or not you're meeting with them. I like meeting with them both individually and together. Some people are intimidated meeting with their soon-to-be ex. So I like doing both prior to the collaborative agreement. I'm going to gather a lot of information, but can I then jump right in, call the two attorneys involved, set up, and the financial person, set up a meeting and talk to them about what I just learned? The answer to that question is no, because I'm now the purveyor of private healthcare information. I can't release that information without a release to do so. And one of the things that I do is right at the start of those first meetings is I explain the situation, I explain what I'm going to be doing as far as the collaborative process in the future. I get them to sign an agreement immediately that I can talk to the other members of the team and discuss what I've learned from them right from the start. And I think that, and it's a HIPAA, at that point, it's a HIPAA compliant release, because my role at that point is as a therapist. It's not I'm not a therapist, but I have a similar role to that. It is not as the collaborative facilitator yet. Once that HIPAA agreement is signed, we move into a transparent. And I also make sure I talk to them about the transparency and the importance of transparency in the collaborative process. But once we have that agreement signed, we then can move into the collaborative process. And for the most part, then we can talk.
Craig, you're approaching it from a mental health professional standpoint in HIPAA, but I refer everybody to 1.3b of the ethical standards under FACP, which is also 1.4b under IACP ethical, the minimum ethical standards. And I caution everybody that before a participation agreement is signed, if the mental health professional were to meet with your clients ahead of time, they are essentially waiving confidentiality by speaking with that professional without a participation agreement. So you got to be very, very cautious about when the mental health professional is going to set up these individual meetings with the individual clients, or have an agreement ahead of time that everything said is going to be considered confidential as if it were within the process itself. So just be aware of that. It's under 1.3B.
Yeah, I usually, as I said, I usually have them sign an agreement right from the beginning that this information will be shared with the other members of the team, so they're aware of what will happen. So I don't have to worry about violating that confidentiality, and we can move into the participation agreement and into the collaborative process. Okay, any questions, by the way, shoot them into the question and answer section or into the chat, and then we'll bring them up later on. I want to also, I hope all of you have looked at the fact pattern and have read it. What I want to do is go over a couple of things that are in it and what we can and cannot do ethically. The first question, there are a list of questions and discussions, and I'll try to make this real short because we'll run out of time real quickly. Can the collaborative mental health professional share information with Ellen's private therapist? If you read the ethical standards for collaborative, the answer is technically no, not without permission. And I would be real careful with doing that. Also, too, if you go into question number 2, what are the ethical implications are there in the collaborative mental health professional communicating directly with Ellen's private therapist? Even if you get, and it's also in paragraph, I believe, number 2, if you are going to talk to that private therapist, and you might have all kinds of agreements, HIPAA compliant forms signed by the therapist, and the therapist can talk to you. Odds are pretty good you don't have a signed agreement with anybody that information can be shared with the team. So you've got to be real careful sharing that information. Okay, and a lot of people are not aware of this. You may get all kinds of information from that therapist. What are you going to do with it? Well, if you turn around now and say, okay, team, the therapist told me I got a borderline individual and a crazy mom or a crazy dad, can I now go and share it with the team? The answer to that is no, because I don't have HIPAA compliant permission to exchange private healthcare information. That's important to realize. I need another agreement signed that whatever I receive from that private therapist, I can now share with the team. If you don't do that, somebody wants to complain, and all of a sudden you turn around and say, hey, dad's a crazy person and did this, and this, and dad now wants to sue you, your malpractice is going to be tapped for a lot of money.
Craig,
Okay.
do you need that agreement with the private therapist or actually with the client?
Both. The private therapist should absolutely know what you're going to do with the information, and the client needs to know what you're going to do with the information. And honestly, most clients at that point are probably going to say, please do me a favor, don't contact my therapist. Because any of us who are therapists, we're going to have lots of information that go way beyond any divorce proceedings or anything else. And you may not want that stuff shared with anybody. Would I go running to the therapist to go talk to them? Yes, you can. Maybe it would be a good idea. They can give you some insights. I'm not so sure it's a great idea to do, okay, for the most part. It just opens it up to too many ethical questions, too many ethical concerns. Another question, can I talk to the kids therapist or that therapist, any therapist, about developing a parenting plan? I'm going to get a one-sided type of response. Also, a parenting plan is, yes, it's for the kids and in the best interest of the kids, but who's the parenting plan for? Really? Isn't it so the parents can effectively timeshare? and be able to see and be with their kids and do things with their kids. So you might get a very one-sided response. In this particular case, you've got, how old are the kids? They're pretty young. You know, they're 5 years of, one child's 5 years old. What's that kid going to tell, that child going to tell their therapist? I used to call it Toys R Us 101. Whichever parent brought that child to Toys R Us the last and bought them gifts is probably going to be the parent that child wants to be with, and is going to think great of that parent. So you're not going to get a very accurate position. Also, do you need both parents' permission to talk to the kid's therapist? The answer is yes. Even though in parenting plans, I think it's 61.1.8 or something like that, I forgot the exact number, you don't need both parents. Once the parenting plan is in place, you only need one parent's permission for the child to go to therapy. Although I caution people all the time, don't be the first one to go before a licensing board because the other parent files a complaint. Okay, it hasn't happened yet, but sooner or later it's going to. But you've got to be careful. You need the permission of both parents. This is your ethical responsibility as a mental health facilitator to get that permission. And the fact pattern we've got, dad said no. So what do? Do you talk to the therapist? Absolutely not. You don't have permission to do that. You've got to be careful. There's also another situation where the MHP abruptly ends the meeting and says we're going to wait a month, but I want to wait on that one till the end and the three of us are on, or the 4 or 5 of us are on, and we can talk about that. There's some glaring problems with that. Okay.
Greg,
in the interest of time, I'm going, what, Jeff?
Yeah, what about when the private therapist contacts you and says, what's going on in connection with the process? Because I want to be able to assist my patient as much as I possibly can.
That puts me.
You want to discuss 1.3A and 1.4A under IACP?
That ends up, I think, you know, if I were dad, the father, the husband, I would not want that to take place. I'd be very much against that. That makes the situation very one-sided. I'm going to help mom get, let's say, more powerful in the divorce process, and I'm now facilitating that.
But what would you have to do under 1.3A or 1.4A under IACP in order to be able to speak with the private therapist? What would you have to do with the group?
I would want to get everybody's, including the attorneys and the financial person's, permission to do so. And I would hope that every other member of the group would say no. That would be my hope and expectation. I know I see some people are shaking their head no, but I'd be very uncomfortable, sharing what's going on in the collaborative process just with mom's therapist or somebody else's therapist without equal for the other side and without the permission of the entire team. And that includes the other client.
That's very important that everybody is aware of the provisions of 1.3A, the general rule on confidentiality. What goes on in Vegas stays in Vegas. What goes on in the collaborative process stays in the collaborative process unless everybody is in agreement to share. So be very, very careful. And I would suggest that if it's the other client who needs to give consent, that there be a full discussion between that client and the attorney on the ramifications of sharing information with the private therapist, because that could lead to certain ramifications within the process itself. It's not a simple answer to the question, but at least stay within the 1.3A guidelines.
Yeah. And also, if you're going to do it, make sure you have that HIPAA compliant release both ways to protect you, protect the therapist, protect your client. All right, now I'm going to turn it over to Eileen to do some of the financial issues before we end up getting too far into the time.
Great, thanks. Jeff, I'm going to comment on your, with regard to the standards that CPAs are held up to. The Florida statute, chapter 455 and 473, specifically 473 relates to the regulations of the professional occupations and accountancy. So we go by not only that with regard to the, which is basically administered by the Florida Department of Business and Professional Regulation, but when CPAs are a member of the AICPA also has a code of professional conduct, which we have to adhere to as well. So that kind of flows into, from the perspective of a collaborative professional and a neutral, and theory-wise, it's basically the same, because from the AICPA perspective, it's independence in fact and appearance. And we can all understand that, right? Not only do you have to be independent or neutral in the case of a collaborative situation, but you also need to appear independent. And I think that's where some of the rules that the collaborative ethical standards kind of picks up on. So I'm going to start with our fact pattern. I'm in the third, the third paragraph down, where basically the clients, see, the financial neutral has begun to discuss the aspects of a special needs trust, okay, only with Bob, which is the father, without the team's knowledge or involvement at Bob's request. The financial neutral wants to fully be immersed in the financial aspect of the special needs trust. So, and I'm going to take it bit by bit because I think it's just going to be easier to explain. And that relates to the questions. If you go to the question page, and I think I'd put question 5 before I put question 4. What ethical issues exist with the financial neutral's involvement with the special needs trust? Okay, you've got your allied professional, which is really the individual that would be there to create the special needs trust. To the extent that the financial neutral wants to participate in the trust, and when they say being immersed in the trust, I don't really think that to be appropriate. The financial neutral has their own things that need to be done and procedures to be taken care of within the collaborative process. But with regard to providing information of a financial nature, which the financial neutral has been collecting during the process, I think, number one, there needs to be consent. So in my opinion, I would bring this up to the professional team first. And then, the clients have to consent as well as with regard to this information being shared. Now, the part of it where the financial neutral in this case is sharing only with one of the individuals, one with the father, that to me is inappropriate. Okay, you've got 2 issues with that. We've got the issue of transparency, right? Everything should be transparent to the whole team. So by discussing and working on something with one member of the team, I think you lose your transparency right there. In addition, you've got, I look at it being lack of neutrality. I mean, how are you being neutral to both clients and protecting both clients and working with both clients when you're off on the side doing something specific with one of the clients? So those are 2 areas where I think you've got a big problem in there, and please, let me know if anybody thinks differently.
Eileen, I also wanted to add that it's important for Eileen and I were discussing this earlier. We also think it's important to note that the first sentence of that paragraph says the parties have discussed the idea of creating a special needs trust. So I think it's also in the team's best interest to discuss the special needs trust before any conversation happens between the financial neutral and Bob, who's in this case the husband, before they get involved in what it means to do the special trust. So I just wanted to add that that's something that should be done in team meetings professional team meetings before and a full team meeting with the both parties to discuss it before Eileen were to have gotten involved in that aspect of the special needs trust.
And if I may jump in and refer specifically to ethical provisions, 1.1D, competency. The financial neutral may not have any competency as it relates to special needs trusts. So make certain that you, if you don't know what you're doing, suggest that you get an expert involved in the matter. It's extremely important. And this is where these outside experts come in. For instance, not every financial neutral is capable of doing financial planning for the future. Not every financial neutral is capable of doing valuations for a business. So make sure that the competency level is where it needs to be if you are any of the professionals, for that matter, not just the financial neutral.
Yeah, and to add to the comment that Rebecca just put into the chat, absolutely, this would be an allied professional in the collaborative process, Rebecca. So the allied, what we're saying is the financial neutral is trying to be completely immersed with the allied professional, which in this case would be an estate planning attorney trying to resolve the issue of the special needs trust for the child. So it is an allied professional that would come in, which is why we think, why I made the comment before that it should be in the meeting with it should be discussed, the professionals first, then it should be discussed with the team before we even go into talking about the financial neutral, even providing information or any of that nature to the rest of to the special needs allied professional that will be doing that.
Yes, and I think that there's one more issue with regard to confidentiality that you have to be very careful of if you're going to be a neutral professional discussing things with the allied professional. And that's as to what information has been shared during team meetings or separate meetings, aside from, that maybe the allied professional should not be privy to. So you get into a lot of you could get into a lot of sticky situations. And I think if in a situation as this, you were going to have your neutral professional, your financial professional working with an allied professional, I think that maybe in professional or regular team meetings, you need to set specific parameters as to what can be discussed, what types of information, and what is, has been consented to. So that's just my opinion in that regard. Okay, so let's go on to, and we can answer some more questions in a little bit. The next paragraph speaks to the financial neutral who is also licensed to sell annuities and other investments, is interested in and talking to the team about the parents purchasing an annuity from that financial neutral for the benefit of the minor child. Okay, specifically, IACP standard 3.6 states that during or after conclusion of a collaborative matter, the financial professional will not sell or recommend purchase of financial products which will result in that financial professional having some financial benefit. Okay, the FACP standards, section 3.5 speaks not specifically to that, but also, talks about not engaging in relationships that will compromise, again, neutrality. So in both sets of standards, not a good idea.
But 3.6 is specific as to that, and it almost recites what your financial ethics recites, indicating that you're not going to have a business relationship. You can't sell products to the parties. So look at 3.6, which is right on point in connection with this particular issue.
Absolutely. And that's correct. So let me just move on. Okay, the next thing, this is just this financial professional is just doing all kinds of wrong things. During the meeting, which involves alimony and equitable distribution, the financial neutral begins the meeting, providing the team and clients with the opinion that Ellen, the wife and mother, should be receiving permanent alimony. And she's done this based on the fact that she will have to continue supporting the minor child. And then also, as you go down a little bit, it speaks to the financial neutral saying that she or he has read case law that, and she or he is basically defining what that case law says and explaining it. So, you know, basically we've got the financial neutral has kind of gotten out of his or her lane, right?
Eileen is just being such a bad girl in this fact pattern, you guys. Such a bad girl.
I'm just pointing out what somebody else did. But really, you know, so the financial neutral one that is so out of place in telling anybody what type of alimony. Financial neutral should basically do calculations, is there to support what the attorneys and what the team come up with and what options they want to be run. So we do the calculating after everybody's decided what types of scenarios or options they'd like to see and look at. So we got to all remember to stay in our lane. And sometimes it can be very difficult. You know, we as for financial professionals, we do read case law, but we have a layman's understanding of what that case law is. That should be left to the attorneys to explain to their clients at all
But
times.
this doesn't prevent the financial neutral in the professional team meetings from expressing their thoughts and opinions. One of the reasons that you have a financial neutral is not just to crunch numbers. They're a very, very intricate part of the entire team, just as the mental health neutral. And their opinions should be vetted and should be well thought about at the time of the professional team meetings. It shouldn't be brought up at a full team meeting, but it should be put out on the table so that the attorneys can analyze it from a financial standpoint, a financial neutrals standpoint. So, you know, don't be shy about sharing your opinions at the professional team meetings. You're not violating ethical considerations by doing so.
That's a good point, Jeff, because the financial professionals often have a lot of experience, and even though we're not attorneys and we don't really you know, practice the law part, we do have a lot of experience in cases that we've worked on, whether in litigation or in the collaborative process.
I think the focus should always be that this is an interest-based process. So specifically in our fact pattern, she brought up the term permanent alimony, right? Even though, as you guys recall, in the beginning of the fact pattern, it's a 10-year marriage. So it's not a long-term marriage, which the attorneys in the group understand what that implies, but it is a 10-year marriage with a child with special needs. So I think that from the get-go, it should be an interest that's discussed with the clients. And then I agree with Jeff, that should be, you know, Eileen should be able to come to Jeff and I and Craig during a professional team meeting and say, hey, I don't know if this has been part of the attorney discussion, but permanent alimony may very well be an option here. And then go from there, elaborate from there. But staying in your lane is so important. I find that a lot of these collaborative cases end up falling when any of the professionals don't stay in their lane. We have to respect each other's roles in the collaborative process in order to be able to move forward and move the case along. If not, the professionals are the ones basically interfering with the success of the process for the clients. So just wanted to point that out.
Liz, I think you can go on and take the last paragraph for us, I think.
All right, perfect. So I'm going to be attorney B, the bad one, because Jeff is such a great person, and I'm going to be the bad attorney in the scenario. I come in, you know, very upset that Eileen promoted this permanent alimony, which has never been discussed in any prior meeting. The clients have never mentioned it as an interest. And I just immediately get this aggressive tone. and get very upset with Eileen and the whole team. And I don't, instead of being with my collaborative hat on, I put my litigation hat on and I start saying, the case law doesn't support this. I don't agree with permanent alimony. This isn't what a judge is going to be giving the clients. And I just get very upset, to which Craig immediately stops the meeting and tells everyone, we're just going to resume in a month. So there's a lot of stuff there, right, guys? There's a lot of issues that come up with that type of, that's like where you don't want your team meeting to end. You don't want it to end with someone being upset. So I want to venture in talking about how that could have been handled differently. One, not only by the attorney, but also by the MHP. Could there have been other options rather than just abruptly ending the meeting? And what came up? Well, one, I started bringing up case law during a team meeting in front of both clients and bringing in what a judge would do. So when is it appropriate to bring in the law into these cases? It's a very fine line. And I think most of the attorneys, we struggle with it, right? Because we are not neutrals, technically. We represent our clients and we want to make sure they're aware. But my opinion would have been, I should have kept my cool. That should have been a discussion I should have had post the meeting with the professional team, address Eileen and what she had mentioned in the meeting, and obviously have discussed that with my client, separately. I should have just kept my cool, because the only thing I created was a bigger problem, and I fueled my client possibly into maybe not even wanting to proceed with the process because of this. Additionally, I don't think it is appropriate to bring case law. I think, again, we should all as a team, as a professional team, discuss what those cases are. If there's a legal problem that comes up that the attorneys need to discuss, it should be done offline. And then obviously that, depending on that conversation, then bring in the clients and discuss. And Jeff, let me know what you think, what you want to add to this. And has this happened to you in a real case before?
First, I'd like to thank Luz for volunteering to be the bad attorney in the team. Certainly out of character, everybody figured it was going to be me. First, I would like to call everybody's attention to Rule 3.4C. The obligation to examine the impact of the professional's own conduct upon the functioning of the professional team and on the collaborative process is very
Jeff, you muted yourself.
great. I'm sorry. 3.4C provides information in connection with professional teamwork and the obligation of the professional to examine the impact of their own conduct on the entire team. So it's very, very important that we become a little introspective on what we are doing in possibly collapsing a process that is not meant to be done in this fashion. If you take positions rather than try to build possible, got all kinds of things popping up, possibilities of proceeding forward and building on the agreements that have been reached, you're making a very, very bad judgment. The other thing is 3.3, good faith negotiation. You should all be familiar with that particular rule under FACP as well. And each client professional takes a thoughtful and constructive approach on all unresolved questions in the interest of reaching agreements. So we can't be positional in our approaches. We can't just come in and say, well, this is what the law is. You may as well take off your collaborative hat and put on your litigation hat. The first thing I was told in my beginner training was I needed to have a paradigm shift. And I didn't really fully understand it until I had several trainings from Lana Stern, who I see on the call, and Bob Merlin and other people who, and Sheila, and people who worked with me on collaborative processes that I was involved in. to make me understand what that paradigm shift was all about. We're part of a team, everybody, and we need to act as a team. And one of the things that has come up in my experience recently is allowing the clients to create a rift among the team members. That's a very, very dangerous situation. We as professionals need to stick together. And it's not us against them, but it's us for them, and keeping them on the right set of rails to get to the end of the process. So I thank Lana, and I thank Bob, and I thank everybody else who has helped me make this paradigm shift in growing in my collaborative process. Luz?
And I want to ask, now that, we kind of went through the whole fact pattern, there's a lot of other issues that can come up with this fact pattern. Does anybody want, if you want to unmute yourself and have had similar situations, we want to know, the panelists want to know, how did you address it? How did you address when the attorney got out of line? Who addressed it? What could Craig have done differently in terms of just abruptly stopping the meeting? What other options are there? So I opened the floor for everyone.
I just want to back up because there's been some questions on what I had said about meeting with an outside therapist. The most important thing to remember is be highly ethical and be very careful. You want to make sure that release, and I think Sheila said it in a great way, that information will be shared with the team. Okay, I think that is very, very important to realize that. That's what I was saying, is being ultra careful, because that therapist might give you information that is really not to benefit the team or benefit the process. And you as that facilitator want to be careful with that. But you want to make sure you've got permission to release it back to the team. That's probably the most important thing you need to do if you do talk to an outside therapist.
I think Randy has a comment.
Thanks, Luz. Hi, nice to see you. It's been a long time. Yeah, obviously I was real fired up in the chat because I've had many, many matters where outside therapists who are not familiar with the collaborative process, and I stress that, who are not familiar with the collaborative process, are fearful about providing us with information. And we may also, again, be hesitant because of privacy and confidentiality and how that information will be shared. I think the most critical and essential piece here is, yes, of course, I mean, my release absolutely specifically identifies what kind of information will be shared. Psychological history, medical history, legal history, family history, relationship history, and they get to check off and decide what I can talk about and what I can't. What I really want to stress, and next month, we're going to present a case where we were prevented from speaking with an outside therapist, which I was prevented from speaking with an outside therapist, which at the onset, if I only could have, I could have helped that client. So, and I could have helped that process in a better way. And I could have helped the spouse of that client to feel more comfortable with parenting abilities, interactional patterns, et cetera. So if we're going to think systemically, I think it's all in the way we present it. We're not gathering information to be used in a court of law. We're not gathering information in an effort to take a child away or to hurt someone. The intention in gathering that information is to have as much information as possible to understand these clients well enough as a team to be able to work with these clients well enough as a team. You know, I always say, and please remember, we come in the middle of their movie. We don't have any idea what happened before. We don't have any idea what happened during. We only have what they give us, right? So if we're gathering as much information as possible, again, with the caveat not to use it against them. They don't have to be afraid of us, and we don't have to be afraid of that. Yes, releases of information, of course, but I think it's so critical that we let them know all of that, which we want to discover, if you will, to use a litigious term in a non-litigious way, is in an effort to help them. And it's all about how we present that. That's what I want to say. So thank you for that opportunity.
Yeah, and remember, this is a fact pattern where we're dealing with a special needs child, right? And I think I agree with Craig in that, you know, yes, the parenting plan is benefiting the parties in order for them to be able to continue having, you know, something set in stone in terms of the relationship between them and the child. But the attorneys in the room, we all know that parenting plan has to be and should be in the child's best interest, right? And what better way than to discover what that best interest is than to have the facilitator really have information from the child's therapist in order to be able to get to that best interest and for there to be meaningful conversation in the team meetings about what that entails. And I think that's the key. That's key because that doesn't happen. You know, you get these cases with 10, 11, 12-year-olds, maybe not so much, but if you have 5-year-olds, 6-year-olds, and especially children with, you know, autism or AD, you know, special needs, I think it's a very important key to the success and to allow these parties to really have not only a good parenting plan, but one that they'll be able to live with and that they'll be able to work well with in terms of the child.
And particularly, Luz, if we're not using a child specialist, which in many, you know, matters, particularly in the state of Florida, we do not. That's not to suggest that we shouldn't, but at this point we don't. So gathering information from a child's therapist about what might be useful for the child, again, can only be helpful. And Sheila responded to some of my comments. I think, you know, we as therapists, and I remember way back, Lana, if you remember, I remember when we were developing the protocols way back, and we talked about transparency, and we talked about that, you know, the facilitator really has the, I think, responsibility to determine what should be shared or not. And we have a lot of training and experience in that. And so we may not decide to share everything. We want to share, again, what's going to be useful and helpful to the family. And if we keep that frame of mind, there's nothing to be afraid of.
Karen had her hand up. Can we go to Karen Sachs?
Thank you so much. I just wanted to say one thing, because I do agree with Randy. What my concern is that immediate instinct of let's not talk to those people because what do you think the child's therapist, the father's therapist is going to say, and the mother's. So we immediately go to cover our own butts. And that's not good because there is too much information there. Let's say we do have all these releases and we're painstakingly taking these times for these releases. Just the fact that the father said no and don't talk to the therapist in this particular case, maybe the facilitator could talk to the father about why it may be important to do that. I think we're so quick to say, no, maybe that's not so good, as opposed to how can we do it better. This is a huge conversation, and I think it's a good one.
Greg?
Thank you.
Yeah, just to piggyback on that, you do need both parents' permission, and yes, it is going to take some private conversations with the facilitator and dad as to why and the importance of talking to the outside therapist. Possibly, you know, when you're dealing with special needs situations, even teachers and PT, things like that, because that parenting plan has to incorporate an awful lot of information about scheduling and about who's going to do what. So it'd be really, really nice for the facilitator to have all that information. And one of the best ways to get it, obviously, is the outside teachers, therapists of all different kinds. But you got to remember, you do need both parents' permission. to do
Randy,
that. And
yeah.
it's going to take some
Right.
discussions, and it may take more than one with the dad or the mom, depending on who's saying no, to try to talk to them to be able to do that. I've had to do that where I've had other meetings with a particular parent and try to sit them down and show them almost on paper why it's important that I meet with them, why it's important that that information I'm going to be able to incorporate into the parenting plan and even into the whole process, not to benefit the parent, to benefit the child.
Right.
That's the key individual. So
Guys,
I will always put that child first.
All right,
That
Craig,
situation.
Craig, looking at the ethical considerations, 3.1, this is the rule on transparency. And to act as a filter may not be available. You need to be very, very careful that you're in compliance with 3.1 of FACP. So just be aware of that if you're looking to act as a filter.
And also the attorneys, I think it's important to know, you know, we're not therapists, right? We're not psychologists. And a lot of the times the parents, you know, post the meeting, I don't understand why they want to talk to the therapist, or, you know, they give you the rant, right? As their attorney. I think as the attorneys, we also have to respect these ethical standards that are being talked of that we're not familiar with, that the therapists have to deal with, that the facilitator has to comply with. So I think that we have to use that to the advantage of the group and be like, you know, we understand, and now maybe be like what Jeff discussed earlier, taking those positions. Oh, my client doesn't agree, and absolutely not, we're just not going to allow it. I think we also have to be a facilitator in a sense and open the door to the mental health professional to do their job and to figure out really what it is before we, you know, just stand by our client and say, no, it's not happening, they're not going to agree, period. Because I think we're very quick to do that as the attorneys in the team meetings. So I think the mental health professionals, this was a very productive discussion, not only for the therapists, but for the attorneys who we don't know any of that. Jeff and I spoke about it in preparation of this meeting. We were both like, what is 420, whatever? We don't know anything, you know, in terms of what the therapist has to deal with, right? So I think we have to have some sort of knowledge in that it's not so black and white, right? There's a lot of wiggle room that we have to respect.
One more thing, Liz, is that different entities of psychology and mental health have different ethical guidelines and responsibilities. And so I think that's probably another great topic for Grand Rounds, Kelly. But, you know, I think, you know, as a systemic therapist, I have, and licensed as a systemic therapist, I have a lot more flexibility and room to talk with different entities of a family system than perhaps a psychologist might. So I think that's another consideration. It's also my training. So it's very natural for me to be talking and dealing with different entities of a system where another entity of mental health or designation in mental health may not be quite as comfortable. So that's another conversation amongst the team that we have to have.
Yeah, Randy's right. The difference in mental health facilitators and the licensing law between 490 and 491, unfortunately, psychologists are much more restrictive on what we can do, how we can do it, and the rules that we have to follow. Yes. Sometimes I can't stand being a 490 licensed individual because I don't have the flexibility I would like to have, especially in the collaborative process.
So it's one of
a lot of the attorneys in this room didn't even know that before coming.
I know, that's why I said it'd be a great topic for a Grand Rounds, Kelly. I'm open to that.
So could somebody, Randy, maybe you could shoot that in an email to me just so I know precisely what you're suggesting. And it is 1:01, and so we do need to end, but on behalf of the FACP practice group and outreach committees, we'd like to thank today's presenters. Great job, you guys. It was a wonderful discussion.
Really great.
Great job on the materials and everything. Really good information, and thanks for everyone for attending. Please remember to send Liz or me your suggestions for future Grand Rounds and to register for next month's session. And everybody enjoy your weekends.
Yeah, great. Thank you all.
Thank you. Thank you very much. Great job.
Bye, South Palm Beach. It was fun.